It's always great to be here. Thank you very much. It's a sort of a North American tradition always to start with a joke. So I'm going to tell you the story about the guy. He's a tourist in San Francisco, and he's down by the water, and he finds himself in a back alley, and he stumbles upon this old antique shop, and he walks in, and there's this sort of Dickensian-looking owner sitting in the corner with a sort of evil grin, and the tourist wanders through the shop, and he stumbles across this sort of brass figurine of a rat. And it's sort of intriguing looking. So he walks over with it and he asks the owner, how much for the rat? And the owner still has this wicked grin and he says, I'll sell you that for $20, but the backstory, my account of how it got all its special powers, that'll cost you $2,000. So the tourist thinks, well, I don't care about that. He gives him $20, takes the rat out. And as he's walking down to the bay, he notices that the real life rats start pouring out of the sewers, all the homeless encampments, the dilapidated buildings, and soon he's got, 1,000 rats behind him. He starts running faster and faster, and they're pouring out in every direction, and he can see the water, 10,000 rats behind him now, and he jumps up onto a lamppost, hurls the figurine into the water, and he watches 10,000 rats swarm into the water and die a horrible, painful death as they all drown. So he gets down off the lamppost and he finds his way back slowly to the store, and the sort of Dickensian guy is sitting there self-satisfied with a wicked grin, and he says to the tourist, you've come back, haven't you, to buy the backstory and the history of that rat figurine? And the tourist says, no, not really. I was sort of wondering if you sell any figurines of a lawyer. So I learned that in practice in Toronto. If you can tell a joke about lawyers, you can charge the clients more. So you always had a few jokes. So look, my wife and I arrived from Dunedin, New Zealand. We'd spent 11 years there. We got to Brisbane in 2005. About a year later, I'd written a few pieces in the Australian, and I got recruited to speak at the Samuel Griffith conference. That was 2006, the last time that Janet Albrechtsen spoke, by the way. And I've been a member ever since of the society. As I said outside, my highlight was always coming and watching John Stone take somebody on. Boy, that was fun. But I consider myself very lucky to have been associated with this organization, basically whose aims are to foster a sane, interpretively conservative approach to our written constitution. And if we're talking continuously operating full-size countries, that makes Australia's written constitution the fourth oldest in the world after the US, Switzerland, and Canada. And I don't think it'll surprise anyone here this weekend to hear that very, very few other legal academics in Australia are inclined to join the Samuel Griffith Society. Last year, it was hard to get anyone to come and speak on the yes side of they were prepared to give the yes side every day on the ABC. We tried to entice a few yes advocates for the voice to come. We managed to get one person brave enough to come, but nobody else would. In a moment, I think I'm going to have a few things to say about our country's law schools, and you'll be thinking it's going to sound more Cassandra than Pollyanna. But I can say right now that the Samuel Griffith Society, as far as I know, was the only major legal organization to come out for no. So not the bar councils, not the law societies, not a few past High Court of Australia Chief Justices, one over-exuberant King's Counsel who liked to call people names. The list goes on. And remember, at the end of the day, it was a 61%, almost 61% no vote. So the title of my talk is going to be the full title, Today's Lawyerly Caste, She Ain't What She Used to Be. My main claims are about Australia, but look, truth be told, just about everything I'm going to say is happening across the Anglosphere and probably more widely than that. So let me begin with a few background facts. In the US, when you give money to political parties, that's public information, and they do lots of social science surveys. So 70 years ago, maybe even 60 or 50, the median lawyer was to the political right of the median voter. Not today. Today, the median lawyer is at least a standard deviation. The lawyers don't know what that is, but there's probably a few people who've done a math degree. A standard deviation or more to the political left of the median voter. So I think in part this aligns with what we've seen, which is a move by left of center political parties away from redistribution of wealth concerns. And for what it's worth, I have I understand such concerns. I think they're wrong on efficiency grounds and comparative advantage grounds, but I have a fair bit of sympathy for them. Those sort of old-fashioned Dennis Healy type left-wing views, which all are compatible with seeing law as imposing external constraints on actions and decisions at the point of application. But left-wing parties have shifted to what you might call the human rights brigade or the social justice warrior iteration of them. And in statistical terms, there's always exceptions. Lawyers as a class or a caste today vote left. They vote for those sort of parties. Some of the most woke PC workplaces are big law firms. If you go into my old big Toronto law firm, when I was there were 200 lawyers, it's probably like 300 now. You'd have to have your pronouns displayed on your chest for ready sight. And I think you'd probably be liable in tort for sudden deaths and seizures if you told anyone you supported Donald Trump. The same goes for pretty much every single big US law firm. Meanwhile, the bar in London and all the big London law firms might even be more woke and overtly all in on progressive politics. I don't think anyone in this room doubts the same is true of Sydney and Melbourne law firms, or the bar councils, or the law societies. And this fact about the sort of moral and political outlook of the lawyerly caste, and again, I'm speaking in general terms, always nonconformists, iconoclasts, heretics. You'll meet many of them in the bar later tonight. But this fact of lawyers having political views significantly to the left of the median voter on key cultural, social, and political issues has consequences. It can affect lawyers' commitment to free speech. So just look at the change in the American Civil Liberties Union over the last half century. It has gone from being so committed to free speech that it defended neo-Nazis who marched through Skokie, Illinois, a town with a majority Jewish population, some of whom were Holocaust survivors, to today's ACLU, which appears not to care one whit for free speech and often argues against it. So it's basically transmogrified itself into a social justice activist outfit with exclusively left to hard left views. Or on the basic issue of a left-wing skew, just consider how few Australian lawyers or ex-judges openly supported no last year. If a bomb went off in this room, you'd probably be impossible to find any. Relatedly, consider how this change amongst the lawyerly caste appears to have affected lawyers' commitment to the presumption of innocence. I mean, here you could be forgiven if your mind strayed to the ACT lawyers as regards Lehrman or the Victorian ones when it came to Cardinal Pell. So the social justice warrior or human rights outlook on life can also lead top judges, I think, to insert themselves into social policy making when the law and the Constitution laid down by those who had the legitimate authority to make law, right, which in all senses other than interstitially means the elected branches or those who drafted the Constitution, and it simply does not give judges that role. And I think, to my mind, this has obviously happened in Australia, but it's happened around the Anglosphere too, and to a much worse degree. So we're the least bad. So overseas example, I lived for 11 years in Dunedin. As I said, it was a wonderful law school, the Otago Law School then. It's not now, but it was then. And one of the very first peer review articles I wrote back in 1993 or something was a sort of sustained critique of their new statutory Bill of Rights. I said it would lead to puffed up, over-powerful judges, and of course everyone poo-pooed that. Well, sadly, in this case I was right. New Zealand's top judges today, I think they see themselves as some sort of imperial judiciary. And remember, this is a British unwritten constitutional setup where parliamentary sovereignty is at the heart of the setup. I used to teach there, but didn't matter. I'll give you two quick Kiwi examples. So 2 years ago, the New Zealand top court decided a case called Make It 16, nothing to do with Epstein. And the judges used their statutory Bill of Rights, the one I'd been warning about, to decide. They actually announced, they declared, that the right to vote should apply at 16, not at Parliament's preferred 18 years of age. Now, you got to follow this. They did this by making use of the most tortured and implausible of interpretive approaches. So basically, they ignored or downgraded the explicit provision in the statutory Bill of Rights that says, voting. You get to vote at or over the age of 18. And then they opted to trump that with what? Well, there was an amorphous anti-discrimination provision, Section 19 in the same Bill of Rights, and it had been amended a few years later after the Bill of Rights had come into force, and it basically had just incorporated another statute that had been written with the full knowledge of the statutory Bill of Rights, and that had just mentioned age discrimination kicking in at 16. So based on that, the New Zealand Imperial Judiciary made this formal declaration that Parliament had infringed people's timeless rights, fundamental timeless rights, and in this case they meant the age discrimination at 16. So the supposedly timeless fundamental right they're talking about only exists because the elected New Zealand legislature happened to enact that it did. If they'd said age discrimination kicks in at 17 or 18, you would have got a completely different result. And in the process, and this is a process that was no less arbitrary, because let's be honest, 18 is an arbitrary age for voting, but picking 16 out of thin air is also arbitrary. And so the result is that the New Zealand judges remarkably held that their statutory Bill of Rights is inconsistent with itself. And of course, they held that the age of 18 was not a justified, reasonable limit on rights infringement. I put it this way, it would be an unusual outside observer who could characterize this as honest interpretation that was seeking the intended meaning of the legitimate lawmakers. On the other hand, in terms of displaying sophomoric reasoning, virtue signaling, judicial self-regard, this Kiwi case, it has to get a podium finish in the Olympic event that's trying to find the worst reasoned constitutional law case in the Anglosphere. Now, personally, and I only speak for myself here, I still would give the gold medal to our own High Court in the Love case. But, and I mean that, to be clear, I mean that as a nuanced judgment. Or staying in New Zealand, a couple of months ago, the same top judges decided this thing called the Smith case. Smith was a Maori climate change activist, and he brought proceedings against the 7 biggest companies in New Zealand for an injunction to stop them from contributing to climate change. This would have been laughed at court when I was a lawyer. Yes, purely political matter, but not if you're part of the Imperial New Zealand judiciary, because basically what Mr. Smith was inviting the judges to do was to become hero judges, inject themselves into this heated debate and create effectively a new tort, something like damage to the climate system. And by golly, they did. This is in a country, again, whose elected parliament has already enacted, under Ardern, an emissions trading scheme. And so, up until yesterday, pretty much, the motion to strike would have succeeded, and that happened in the 2 lower courts in New Zealand. But the New Zealand Supreme Court reinstated all of Smith's claims, and it's gone back to first instance. My view, this is just judicial usurpation, not to mention a sort of indication that these judges are puffed up and sanctimonious on steroids. I could, if I wanted, talk about myriad cases from my native Canada that shows that the top judges there are even more inclined to gainsay the elected legislatures. I think here in Australia, and I've said this many times, the whole implied freedom jurisprudence is completely implausible. Now, by that I mean this. I think I'm one of the most pro-free speech law professors in the country, so I like some of the results. But honest interpretation is not equivalent to get the answer you want. Right? If your wife gives you a shopping list and you come back with all the stuff you wanted, that's not honest interpretation. And if you go back and read Mason in the ACTV case, no one can honestly say that the judges weren't making it up. 4 years, by the way, after the failed 1988 referendum, which most of the judges were on side for, just as it happens. So after 90 years in the sort of mysterious innards of our written constitution, they discovered this implied freedom. You say discovered, I say created out of thin air. But what it does is it takes matters off the democratic table. And you need some warrant for that, or apparently you don't. So it goes without saying that this judicial adventurism is overwhelmingly supported, not by everyone, by most of the lawyerly caste. It's almost as though lawyers have a sort of enervated regard for democratic decision-making, again, speaking generally, or consider the lawfare that's happening in the US right now. Doesn't matter what you think about politics. But the legal caste is clearly showing a significant disregard for democracy. So consider, for instance, the attempts that were made to have former President Trump removed from the ballot using the 14th Amendment. At the state level, it had some success in some states, and only at the US Supreme Court was the attempt quashed. Admittedly, 9-0, thank God. But just think about that for a moment in terms of democracy. Now, you know, democracy is like many ideas, it's a contestable concept, so you can have thinner, more morally Spartan understandings, or you can have fatter, more morally laden ones. And the former see democracy really in procedural terms. You focus on how is a government chosen. And there's obviously a bit of a tiny moral overlay on the thin account. You know, were you voting with, by having to put your hands up with guys with machine guns around you or something? That's not really finding out what people really think. But the moral overlay is pretty small. You know, the basic question is, did the numbers count? At the other end of the spectrum, which way too many people buy into, I think now, you get this procedural account and you add in a big dollop of substantive moral overlay. So now you basically ask not only how was the government chosen, but is it sufficiently rights respecting, or did it meet some further set of moral thresholds? And this fatter understanding of democracy has become ever more popular amongst academic lawyers. It's completely bought into by most NGOs, and I think most in the lawyerly caste. And it's a very dangerous understanding of democracy, this morally pregnant one. And it's dangerous for the simple fact that when it comes to big ticket moral evaluations, they are debatable. The odds of you being the pinnacle of moral evolution after 4 billion years are pretty small, right? The idea that your moral antennae vibrate at God's perfect frequency, the odds are against you. It's a bit like pretending that the concept of representative government, and that's sort of, to a large extent, undergirds the discovered, made up out of thin air, implied freedom. It is wholly and completely contestable, and it's not constraining in terms of deciding the issue before the court. Or if you want to put it enigmatically, never forget that plumbers can disagree with lawyers. So nice, smart, reasonable people tend to disagree about what's rights respecting. When I debated George Williams about a Bill of Rights back in about 2008, I'd always start by asking, who's in favor of the right to free speech? In the sort of amorphous, generalized terms, even the guy with the brown shirt and the little mustache put his hand up. But, you know, when you start giving people examples of, do you want billboards outside of schools that allow for tobacco advertising? That was a big Canadian Supreme Court case. They ultimately reversed it. But there's all sorts of line drawing you don't agree with. And so because nice, smart, reasonable people disagree about what's rights respecting, they also tend to disagree about what's a reasonable and proportional limit on rights. And so it's better to say this government is democratic, but we as a group, or this particular group, we think it's come up short in some moral way or some rights respected way. But the tendency today is just to say, well, it's not a democratic government. That's the EU approach. So as it happens, I think that sort of general criticism has a bearing on proportionality type analyses. And these have a huge, we heard Justice Edelman and the entire High Court. It has a huge attraction for judges across the Anglosphere, right? So it's worth mentioning a British academic. His name is Thomas Poole. He's a man of the political left. And I love to quote him because he has said, and I quote, "Proportionality analysis is plastic. It can in principle be applied almost infinitely forcefully or infinitely cautiously. It produces an area of discretionary judgment that can be massively broad or incredibly narrow or anything in between." So the point Poole's making, and I think he's right, is that this sort of a bridging inquiry or proportionality analysis is just a thinly disguised vehicle for legislating at the point of application. If your Bill of Rights explicitly says to the judges, do this, fine. But here in Australia, they just gave the power to themselves. And it's not a dissimilar point to the one that the US legal philosopher Lon Fuller made, back in 1949 in his magisterial little article in the Harvard Law Review called The Case of the Spelunking Explorers. And he has one of his mock hypothetical judges say, and I'm quoting Fuller, I am personally so familiar with this process of how my fellow judge approaches these issues that in the event of my brother's incapacity, I am sure I could write a satisfactory opinion for him without any prompting whatever, beyond being informed whether he liked the statute or not. And let me be blunt. I am immodest enough to think that I could do the same as regards every single justified limit, abridging inquiry, proportionality analysis that has ever been undertaken by any judge in the democratic world. And I don't mean that rhetorically, I mean that literally. All of them, including the high court ones here, you just tell me the answer you want, and I think I could write up a wholly plausible, orthodox judgment in the language of proportionality analysis that delivered the outcome for the side you want. And remember, we're talking about this in the context of the incredibly aristocratic power involved in invalidating laws by the democratically elected legislature. And notice further, when top courts decide anything, they always use this decision-making rule. Canada, it's 5-4, Australia's 4-3. 5 lousy, insipid judgments that were written by your law clerks beat 4 wonderful, insightful, perfectly reasoned ones. It's always majoritarian, it's always procedural, because it has to be. So put it no higher than this. Undergirding much of what we can observe around the common law world as regards the trend towards imperial judiciaries, there's this sort of unspoken premise that plumbers and secretaries really do lack the finer insights and moral sensibilities that you come with a good caliber law degree from Oxford, Harvard, or Sydney. And I wrote this before the admittedly somewhat diminished institutions based on these horrible pro-Hamas, pro-Palestinian encampments. But as top courts take over ever more social policy matters off the democratic table, what comes along with that is the issue of judicial appointments, at least for right-of-center political parties. It becomes ever more important. Now, the Republicans in the US, after decades and decades, appear largely to have sorted this out. This, how do we appoint an actually interpretively conservative judge? How do we do that? They seem to have sorted that out. They've grown a backbone and some perspicacity when it comes to making judicial appointments. But that is not obviously true as regards right-of-center political parties in Canada, New Zealand, Britain, or here. And if you're saying, and yes, it's true, by saying that, I am implying that I am a tad skeptical about the coalition's approach to judicial appointments, which basically says, hey, let's appoint the retiring guy's wife. Or maybe one of the appointees has a daughter we could put in. It's such an embarrassment. So look, I have saved the most depressing part of this talk for last, because I now want to turn and say a few words about the law schools, because otherwise people in this room might get the mistaken idea that I think lawyers and judges, that part of the lawyerly caste, are worse than the professoriate. They are not. The law schools are in a very woeful state. So if we go back to those statistics of the left-leaning nature of lawyers, the law schools, by comparison, make that one-sided bias basically pale into insignificance. So if you go back to the US, where donations to political parties are public information, someone named Professor Derek Mueller of the Notre Dame Law School, so top 25 law school in the US, he's looked at all of the Federal Election Commission data in the US, so the FEC, all of the data from 2017 to 2023, all the donations made by every single US law professor who has donated money, and I will quote him now, quote, "In the end, I identified 3,148 law faculty who contributed only to Democrats in this 5+ year span. That was 95.9% of the data set. Another 88, that's 2.7%, contributed only to Republicans, and 48 others contributed to both." So for the probably fairly hefty number of enumerate lawyers in the room, that's a 36-to-1 ratio of progressive left law professors to conservative right ones in terms of people who donate money. We can speculate whether Republicans or Democrats are more likely to donate money, so it could be even worse. So law schools around the Anglosphere, and I'm afraid it's true in Australia as well, they're basically on their way to becoming conservative-free zones. Viewpoint diversity is not just collapsing, it's largely collapsed. And remember, many parts of the universities are far worse than the law schools. So the American academic and man of the political left, Jonathan Haidt. So he's a Democrat, but he laments what's happening. He's written books about it. He details it in chapter and verse. There are departments like anthropology in the US that run about 56-1. There's some departments where you can't find a Republican. And he said the most conservative-leaning department in the whole of a US university, he's generalizing, would not have one conservative to every 5 left-wing progressives. That's the best you can do. Probably engineering if I were guessing, but I don't remember. So that's under 20%, and that's as good as any university department gets in terms of viewpoint diversity. Or look at the UK. There was barely a single legal academic in the whole country who put his or her head up above the parapet and said, I favor Brexit. And yes, I have to say, by all accounts, every single UK Supreme Court judge who sat on each of the 2 Miller cases was a Remainer. No one has ever contested that. So that's 11 justices on each of the 2 cases. If you were sort of an outside observer from Mars, you might say, that sort of suggests an appearance of bias. At least it goes some considerable way to explaining the 2 incredibly unorthodox, I would say implausible, conclusions in those 2 Miller cases. The first one on the prerogative power and the second one on proroguing Parliament, which is fine to do apparently unless you're proroguing Parliament to try to get Brexit through. So I'm sure it's just a chance that both those UK Supreme Court decisions made achieving Brexit so much more difficult. Well, there's probably some other explanation. I don't know what it is. So at this point, I suppose you might try to run what I'm going to call the ABC defense. You sort of assert that institutions that are wall-to-wall left-wing can nevertheless be pristinely neutral and disinterested. In the legal context, the claim would be that the incredible orthodoxy and uniformity of outlook in no way affects the disinterested application of the law or how law is taught in the law schools. If you can say that with a straight face, I suggest moving to LA looking for acting work because, you're gifted. It's certainly not true in the university context. I leave it to lawyers whether they think it's true in terms of how law is interpreted and applied. Let me then, getting near the end, just say, were we to return to Australia, I would have to remind everyone here that we have something like 40 law schools in the country. We turn out more lawyers per capita than the Americans now. It's disgraceful. And you could count on one machine operator's hand how many legal academics came out publicly for no in the Voice referendum. They're almost all in this room. Maybe 4 all up, maybe 5. Meanwhile, I can't think of a single legal academic who is likely to be a coalition voter at some law schools in this country. Or consider this. If, like me, you detest as patronizing and condescending the sort of ritualistic acknowledgement of country, which now in some universities they say before every class, and you just won't recite them, you simply cannot get a senior administrative position at an Australian university. At the same time, and I am positive this is true, if you were unwilling to sing the national anthem or you would not celebrate Australia Day, that would not hurt you at all. You would also not get a university administrative job of any sort in this country were you to be open and public in believing and saying that sex is a biological fact that is imposed on people by the external causal world and not a function of someone's preferences or druthers. Nor were you openly to lament, and I always come into work wondering, how many flags will be on the registry building today? Will it be 8? Will it be 7? Will there be any color on the spectrum that's missing? Probably not. If you lament that, you're not going to get a job. And now, I'm not saying anybody sane would want a job in a university administration right now. But remember, I said there were 40-odd universities in this country. I can't think of a single one with a vice chancellor who would likely vote for Peter Dutton. And not a single one that's not a single one at 3.5 dozen odd universities. A country where the voters split basically 50-50. Relatedly, there's no law school in this country where right-of-center academics account for even 1/5 of the faculty. I am pretty sure that this is Chatham House rules, this one, but I'm pretty sure that my law school UQ is the most conservative in the sense that I think we would have the most coalition voters in my law school, and by far, we're probably 15%. And so that gives us a critical mass, and we all get along. But there's no other law school that would, you add up IQ, it's about the same. Yeah. So that's about 15%, and it's going to fall over time. There's no two ways about it. And note that for each year, each and every year of the 9 years of recent coalition governments, the universities got worse in terms of collapsing viewpoint diversity. They got worse in terms of wokery on campus. They got worse in terms of students feeling they had to self-censor. They got worse in terms of free speech and academic freedom. And just saying academic freedom, should we talk about the disgraceful fact that the Libs did nothing to support Peter Ridd? Nothing. And you can guess my view of the High Court decision, where you spend half the judgment virtue signaling about academic freedom, and then it turns out it doesn't mean anything because the code of conduct wins, a disgraceful decision, but nuanced. And yet the Libs' solution to all this was to meet with the vice chancellors. They are the problem. Or, we'll get a retired chief justice to come and look at the papers, the codes of conduct. All of those are discretionarily enforced. They are not going to be enforced on some viewpoints. Let's look at what's happening on campuses right now with the current encampments. It's just bog standard trespass. Trespass laws are discretionarily enforced. But it's when people say it's free speech, like Mark Scott, well, it's bog standard U.S. First Amendment analysis that the pro-Palestinian encampments are not strictly a free speech issue. Not unless you believe that someone can pick up a loud-hailer, walk onto your front porch at home, and say whatever he wants for as long as he wants without you being able to remove him. At any rate, let me put it no higher than this. We have a big problem with law schools in Australia. Conservative academics like me, I'm not saying we're a dying breed, but if we were dinosaurs, we'd be looking for the comet. But in addition, the syllabuses, I never know if that's a false Latin. It might be syllabi, syllabuses, I don't know. It's one or the other. For many courses, they deal in power and activism and grievance and seeing the world through the lens of oppressor and oppressed. And this is the majority view in first-year classes that students are exposed to. And that's the path, that delivers us indoctrination factories for identity politics and for one-sided politics. So never forget, what the law schools churn out are tomorrow's lawyers, and the day after that's judges, which is why what the Samuel Griffith Society is doing is so important. It's also why, in my humble opinion, anyone who gives money, and there's some wealthy people in the room, but anyone who gives money to any university in Australia is making the world worse, not better. And I mean that seriously, because you have to remember that money is fungible, and however much you try to cabin off your donation for some specific purpose, that just frees up the university to spend as it wants, which will be on more diversity, equity, and inclusion bureaucrats, because they love them. So I'll finish lastly with this. There might be some coalition politicians in the room. What do coalition politicians think the world is going to look like in 20 years if this is what the law schools and universities look like right now? Remember, last year there were 4 or 5 openly no legal academics working in the universities for The Voice. Does any sane person, and I think that still includes some coalition politicians, but does any sane person believe that would be true in a couple of decades, that you'd find 4 legal academics openly supporting a no case then? So organizations like this one are more important than ever. We give young students, the ones in the room, a chance to hear other views, and they don't have to self-censor here, because I think the fact of the matter is that today's lawyerly caste just ain't what she used to be. Thank you.